All right, welcome to the Utah Court of Appeals. Thanks for indulging us with a brief break. We're going to call the case now of In Re BD. It's case number 2023-0620. If I could have the attorneys who are involved in that case state their appearances for the record, please.
Colleen Coburg for the appellant.
Good morning, Ms. Coburg.
John Peterson, Assistant Attorney General for the State of Utah.
Good morning, Your Honors. Heath Hackey with the Office of the Guardian Ad Litem.
All right, good morning to you both. Looks like I see 8 minutes on the clock. That means 7 is reserved for rebuttal. Okay. Any questions before we begin?
No, Your Honor.
All right, we look forward to your arguments.
May it please the court, counsel, I want to say this is a happy day to meet my friend Heath Hackey here. I have not argued against him here. We used to be assigned in the same courtroom down below. And I'll tell you that he's a brilliant man, and many times I observed that brilliance, but most of the time it was when he was agreeing with me. So we can't all be right, and he's with Mr. Peterson today, who we all admire for his scholarship and his dedication to the law, and I'm against all of them, which explains why I kept so much rebuttal. But I want to tell you why I think this case is important and why I think I'm correct on this occasion. Many times I've filed appeals where I've sought clarification on what neglect or abuse are, and many times this court says it's one or the other, but it doesn't matter. The legal effect doesn't matter. This is an occasion where it is dependency, and it emphasizes why it matters. Because as the court well knows, there is a loss of parental presumption no matter what the finding is, dependency, abuse, or neglect. I want to focus in this case on the fact that dependency is not a default finding, and whether this court gets a sense of it generally, or whether this case is something that seems unique to you, that there is a perception that whether it's abuse or neglect doesn't matter, and whether its dependency is legally insignificant, and that is basically a default. If it's not abuse
Before
or
we get
neglect,
too deep into the merits, one of the things they've told us in response is that you're raising a bunch of unpreserved claims. Did you preserve the argument below that the conduct at issue did not meet the statutory definition of dependency?
Yes, I did.
Did you also preserve an argument that there's a constitutional problem here too?
I believe I did.
Let's work backwards. Where did you preserve the constitutional argument?
The constitutional argument, I believe I raised in my oral argument the day we talked about the finding. We had an argument about the finding, and the court issued the factual findings and then the legal conclusion later. But we had a vigorous argument related to whether there is a dependency finding or a no finding, and that is preserved in the record.
Okay, so I haven't read that transcript yet, but you're telling us that if we go back and we look at that transcript, you made the argument to the juvenile court that it would violate your client's constitutional
I
rights.
believe that I did. I can tell you, though, that I didn't go back and read that transcript. I was trial counsel, though, and my whole focus with this case was just getting to my point, is that even if the juvenile court makes factual findings, making factual findings is not tantamount to an entitlement of a legal conclusion. And I have argued before in front of juvenile court judges that you can make findings of fact and that it can equate to a legal nothing. Yes, I'm finding all of these facts by clear and convincing evidence and looking at the available definitions in the statute of neglect, dependency, abuse, chronic sexual abuse, that it is a legal nothing. And here, I want to emphasize that the definition of dependency is without proper care through no fault of the parent. And what gets emphasized below is no fault of the parent. Well, if we're here, but it's not your fault, it's dependency. I want this court to focus on, in evaluating this case, which I asked the juvenile court to do, that aspect of without proper care. And in this case, the facts are, and the facts are found, that they're not in any dispute, and everybody agreed to them, is that the minor had psychological problems, psychiatric problems. The parents had taken the minor to the emergency room. It was suggested that they go to uni. They did. The child was in uni getting care. There was no interference in that care. There was no abdication of the care. And it was upon the minor's discharge that everybody, DCFS was aware of it. Everybody was in agreement. This child is getting the care it deserves, and the parents were paying for it. Then when the child is going to be discharged, the division wanted to be in charge of what happened to the minor. And then,
One of the things they're telling us, separate from preservation, is that you conceded this below. You conceded juvenile court jurisdiction, and in the fact that you conceded dependency by not either asking for placement back at the shelter hearing, or by stipulating to the child's removal and continued removal. Are they wrong about that, and if so, why?
I was taking notes, so I want to make sure that I got that. Conceding regarding
Right, my
not
takeaways from-
arguing at shelter.
Right, from the briefing, I understood the state and the guardian ad litem to be arguing that both of those things, either individually or collectively, constitute sort of a concession from your part, that when your client doesn't seek placement of the child, when he doesn't ask for custody back, that he's in effect conceded that the child's not receiving proper care.
Would you mind telling me the second aspect,
And the
not
second one
arguing
is-
at shelter and then,
I took from their briefing that they're arguing that you've in effect stipulated that the child couldn't come back to the home, and that by doing so, that was something of a concession, that there's a dependency situation. That's what I
Well-
understand that to be arguing.
okay, so this is why I don't agree with that. And
Ooh, we're gonna have to have $1 in the swear jar.
We are. It's my child.
That'll be enforced later.
do you want, do we
Everybody
need
else,
to,
make sure your phones are on silent.
do we need to take a break?
No.
Regarding that shelter argument, this court routinely, and I think recently, has talked about the fact that what you can appeal and what you cannot appeal, and shelter is one of them. At that point, if you look at even the factual findings, my client agreed that the child should be in Huntsman, and that child was in Huntsman. So my client didn't feel like I should have custody of this child at this moment, because I agree the child should be in Huntsman.
And in
That
their
is a
view,
red-
I mean, perhaps I've misread their briefing, but in their view, that seems to be a concession.
It-
That's what I think they're telling us.
And I say to that then my client would have to actively disagree, even by coincidence, with the division to say, I'm preserving my right. My client acknowledged at that point that the child needed inpatient psychiatric care and intended to keep the child there until discharge. And that's when the petition was filed. So my client is like, this is my child. I put the child in Huntsman. I put the child in Huntsman because the child needs to be in Huntsman. And I agree that the child should stay at Huntsman until discharge. And then at that point, everybody was determining what should happen. So I don't agree with that. And if the court would look at it that way, you must preserve and ask for a custody return at shelter, then I would say that parents shouldn't have a right to appeal a shelter determination. And you have repeatedly said no.
Let me just make sure I understand factually. The shelter hearing took place on May 2nd, which was the day after the filing of the petition, right?
I'm going to go with, that sounds about right. I don't know the timeline. But
And as I understand it, you were appointed counsel for father at that hearing.
that sounds right as well.
So, I mean, you tell me, you were there. But that was the first time you got the file in this case. That's the first time you met your client, right?
It would have been either that day or the day before. But yes, my understanding, and I think it was accurate at that time, is that the child needed psychiatric care, and my client understood that and wanted the child to stay there. And that's kind of part of my argument about proper parental care. I want to point the court to a case you decided after briefing was completed here, State in the Interest of AS and JS, 2024 Utah Act 52. That was a neglect case, but you started talking about in response to an invitation I'm giving you, define what dependency is, define what abuse is, what neglect is. That was a neglect case, but you talked about proper parental care being reasonable and the ordinary range of permissible parenting. And here, at the time that we went into the factual findings, my client had taken the child to the emergency room, had followed up with appropriate psychiatric care. The child was going to be discharged, had been active in that care, wasn't resisting it in any way, shape, or form, had responded appropriately when the child had made false allegations of abuse, and was actively engaged in what should happen upon discharge. Should the child go home? Should the child be placed with somebody else? And what the situation is here is simply that based on that exercise of proper parental care, the division simply says, yeah, we want control over what you do from here, based on what might happen. And it is my argument to this court that what might happen is not a basis for jurisdiction and a finding of dependency based on the facts here, which is no one has pointed to improper parental care.
Well, specifically in terms of that, and please tell me that I'm parsing this too closely or carefully. So the findings of the juvenile court contained in pages 100 through 102 of the record, finding 13, factual finding 13, there was an interview with the police, and in that, or I don't know who the interview with was, a detective specifically, there were allegations of abuse made by child. And then in 17, child threatened self-harm if returned to mom, but also did not want to return to dad. In 19, dad denies the abuse, but agrees that child needs ongoing psychiatric care. And there's no follow-up to that finding that father, dad is willing to take responsibility for the ongoing psychiatric care. Is that just not in the court's factual findings, or is that true?
Okay, so if I think the timeline or the facts that you outlined are correct, definitely. I would encourage the court to be very careful as to whether you're talking about the one parent or the other.
No, I know.
The other thing is the statement that my client agrees the child needs ongoing psychiatric care. One of the problems that I have is this loosey-goosey kind of analysis where the finding has to be by clear and convincing evidence. And I think what I experience, and I think what we're engaged in now, is looking at those words. The father agrees that the child needs ongoing psychiatric care, and reading something into it that is not there. It doesn't say the father agrees the child needs ongoing psychiatric care,
I'm not willing to help.
and he's not going to follow up. That's not there, and it's the state's burden, and that a finding that justifies that the child is without proper care has to be in the findings. You can't read it in that, and I submit to you if the opposite was the case.
Okay.
Father respectfully disagrees that the child needs ongoing psychiatric care. They would hop on that and say, hey, wait a minute, we're the state of Utah, we know better, and we've decided the child needs psychiatric care, so we think you're neglectful for not agreeing with us. And of course, that is a whole other conundrum about medical care. However, this is why I'm here to ask for this clarification, because there seems to be this overabundance and, well, we're just assuming that if there's findings, then they're entitled to have jurisdiction, right? They're entitled to their finding, they're entitled to jurisdiction. That says exactly what it means. Dad agrees that the child needs ongoing psychiatric care, and the rest of the body of the facts supports that he's gotten that. So if you're going to draw an inference, the inference is because of his response, his appropriate and timely and proactive response in getting the child psychiatric care up to that point, if there's an inference to be drawn, the inference is that he will continue to get proper care.
Can I ask a question that may seem simple, but I just don't know? You had asked at the adjudication hearing or disposition hearing, you had asked for a no finding. Would a no finding continue the jurisdiction of the court?
Yes.
Okay.
Because first off, they're two parents, right?
Well,
Okay.
And
as to your client, it wouldn't.
no, that's not right either. I respectfully disagree because I think it's the disposition statute or the shelter statute that gives the court the authority to
Protective
order a
supervision.
non-offending parent essentially to follow through with anything. And I think it even says any other person. So and I conceded
I'm
that. There
I'm
was that
confused.
argument, well, if
Yeah,
we
me
don't,
too.
I'm sorry?
We've got to unpack this because now I'm confused. So I thought the jurisdiction of the court over the child springs into being upon the filing of a petition, usually by the state, alleging either abuse, neglect, or dependency. And from the period that that petition is filed until the adjudication hearing, jurisdiction exists merely by virtue of the fact that there's been a petition filed alleging those things. And that's what allows the court to make temporary orders at the shelter hearing about removal and custody and those kinds of things. Do you agree with me so far?
Yes.
Then once we get to the adjudication hearing, the jurisdictional question then is going to depend on the findings made by the court at the adjudication hearing. If the court were to find abuse, neglect, or dependency, then the court then has jurisdiction over the child for the remainder of the case and gets to make disposition decisions and potentially even termination decisions and so forth and so on, right? You agree with me there?
Correct.
But if the court at the adjudication hearing doesn't find abuse, neglect, or dependency, in other words, makes a no finding, I can't find on this evidence that there's abuse, neglect, or dependency, at that point, as I understand it, the court loses jurisdiction over the child and the child has to be returned to the parent.
I agree with your analysis to the point that if there was one, say the other parent was deceased. in
Yes,
this
if
case.
there's just one parent.
If there was just one, say the other parent had a tragic car, all this stuff happened, the other parent died in a car accident between shelter and adjudication. I agree that that would be the case if the court had taken my argument that this is a no finding. There's no suggestion that my client can't parent on his own. That would have terminated jurisdiction. However, in this case, the court had jurisdiction over the other parent. The other parent had not adjudicated yet.
But when you're asking the court for no finding, when the record tells us that you're asking the juvenile court for no finding, what I understood that to mean was that you were saying to the court, you should not find the child delinquent as to father, right?
Well, not delinquent.
Not delinquent, dependent.
Dependent. I slipped of the tongue. It's been a long day.
Correct.
That you were asking the juvenile court to say that the child was not dependent as to father, right?
Mm-hmm.
So if I'm tracking all of this right, I think this was kind of where we're going with those questions. The juvenile court would not have jurisdiction as to father,
In other words, the parental presumption at that point as to father would be restored.
would be restored.
And
instead-
father would be then entitled, unfettered by state interference, to make decisions about the child. Mother still has to deal with the state, but as soon as there's a no finding made as to father, father's parental presumption is restored.
Correct.
And
That
so,
would,
so the
that
juvenile
would have,
court does not have jurisdiction to enter orders vis-a-vis father.
I don't, okay, so your question is, does the juvenile court have authority in an ongoing case to issue orders against my client?
Yes.
After a no finding? Yes, because the statute says that the non-custodial or non-offending parent, the court can make orders against them. So yes, the Juvenile Court Act provides for circumstances where one parent is getting services and the other parent is ordered to do whatever, even if they have custody, including bring the child to therapy, bring the child to visits, things of that nature, and it's contained within the statutes.
Okay,
In
but
this particular.
those orders would be then related to what's happening with the other parent.
Right, and I conceded that at the oral,
Yeah, okay.
at the argument on it. I said, the state said, but we have to, come on, we gotta have a dependency finding, because if we don't, then we have to get out of the case, and I
Well,
conceded.
no, I don't think that's
No.
what they said. They said that if there's a no finding, then we have to return the child to father.
That,
And
yes.
that's true, right? They don't have to get out of the case entirely because they've still got the case with mother pending. But at that point, when father's parental presumption is restored, father then could take the child and the state wouldn't be able to tell him he can't.
Well, subject to the court's jurisdiction regarding the other parent. So the court still would have jurisdiction of the child, because my client's finding or lack of culpability, for other lack of better terms, can't destroy juvenile court jurisdiction over the child when there's another parent.
Understood, yeah.
So that remained and had not been adjudicated yet. And what I'm asking you to envision is a circumstance where, say that the other parent had abused the child, because sometimes there is a parent that presents as non-offending and the other one's offending. It is in societal interest to fix the other parent, right? So what would happen is the case goes on with the other parent, so services can be provided. The court still retains jurisdiction over the child to make orders, but my client's parental presumption would not be lost because my client didn't do anything wrong.
Right,
However,
okay.
the statute is drafted to envision a circumstance where he doesn't have to take a hit with a dependency finding, just so that the court can exercise the remainder of its jurisdiction, which is assisting another parent to fix their parental defects. And this is precisely why I'm here, because I come against these situations time and time again where so many parents get swept into this dependency finding that they think is not significant because it says no fault. And these are this is why we need to do it, because we have to take care of the child. He was in a position he could have taken care of the child with the court's supervision of him, which is pursuant to statute, while the court handles the problem of the other parent being abusive.
Let me ask you one more question before you sit down. I'm going to have the same question for the guardian. We want to be respectful of the party's pronoun choices in any decision we render. You represent father. I don't know what you know about mother, but what can you tell me about pronoun choices for your client, mother, and for child?
And first off, I would like to apologize because I'm the worst offender there. The mother in the case had been born
Well,
male and had a gender reassignment. And
yeah, as of right now, what's your understanding as to what the pronoun choices are for your client, for mother, and for child?
for dad, and at this point, I'm not sure about child, because even when I was in the case, I think it switched. And I have not been involved.
Well, let's start with your client.
Dad,
Right. Pronoun choices. Is it he, him?
he.
He,
Yes,
him?
He, him.
Okay. And do you know about mother?
She is,
She, her, as far as you know?
yes,
If anyone else has any information on that, let us know.
and I appreciate that.
And I'll let you talk about child. Okay, thank you. Anything
So,
else?
No, just the summation that looking at the facts, there is not an absence of proper care by my client. And I implore the court to correct this impression and this injustice where he takes a dependency finding after doing everything right. And the transcript of the AG acknowledges he did everything that we wanted. We just want to be in control in the future.
All right,
And that is
thank you,
inappropriate.
Ms. Colbert.
Thank you.
All right, and you folks are going to split your time right down the middle, looks like.
That's correct, Your Honor.
Okay, excellent.
May it please the court, and I can only anticipate that Ms. Colberg's comments, and although well taken, were only meant to take up some of my time and return that. I appreciate her comments. I have a lot of esteem for her. I think what's important for the court to recognize in this case, and I want to start with the no finding, which was Your Honor's question, and then work our way back, because the no finding, it's our position, that's not a legal reality. It's a legal fiction in the context of the juvenile court. And if you look at first of all, the finding goes to the child. It's a status finding as to the child. Is the child abused, neglected, or dependent? If we look at the language of the statute that gives the juvenile court jurisdiction, it states any proceeding where a child is abused, neglected, dependent. That finding is not really as to the parent, it's as to the child. It's been interpreted that way in the, I believe it's the MA case. I'm happy to supplement that authority, but I think the court has consistently identified that that's.
So if I'm tracking that correct, you're saying she's got it right in what she just told us about the jurisdictional implications of what are going on, what's going on here.
I'm sorry, Your Honor. I
In
didn't
terms of the
understand
court, the court still has jurisdiction, even if she's right that there should have been a no finding as to dependency, as to father, you're saying the jurisdiction.
No, let me clarify that.
Okay.
We do disagree with that. And in fact, that there's no finding in the hypothetical where you have a non-offending parent that steps in because there was an incident with the child and that parent came in. Our position would be that that doesn't form the basis for the court to have jurisdiction. We would in fact oppose that petition because
Over
if,
the
for
parent
example,
or over the child? I mean, the court still has.
over the child. So if, for example, you had a non-offending parent that stepped in because the child was involved in an incident that may rise to the level of neglect with an offending parent, and then the non-offending parent with no allegations whatsoever as that parent intervened in that moment and took the child and was perfectly fine, it would be our position that we would oppose that at trial, saying that the court lacks jurisdiction because that child is not neglected. That child is in the hands of a perfectly capable parent. So the idea that we would have a no finding as to a parent in our minds is a legal fiction. It doesn't exist. It goes outside the scope of that particular statute. But I want to refocus the court's attention in this particular case and draw particular emphasis.
So
Sorry.
if there had been a
I'm sorry.
finding at the conclusion of the adjudication hearing in this case that father had not abused or neglected the child, and that the child was not dependent. In other words, that father could provide the care that the child needed. The child was not without proper care. In your view, what would have happened then? The child would have gone home with father, and then what would have happened to mother's case?
Correct, and I'm not making that up. That's the way the statute reads. Because if the child is not abused, neglected, or dependent, the court lacks jurisdiction under that statute.
Well, the child may very well have been abused by the other parent.
Mm-hmm.
So the only finding made at this hearing would have been that there was no abuse, neglect, or dependency by this parent.
Right.
But there's still an allegation pending that's yet to be adjudicated because the adjudication got bifurcated here.
Right.
That there's still an allegation pending that the other parent committed serious abuse against this child.
But it would be our position, and we understand looking back that the court may find that abuse, but at the time that the case was adjudicated, we would take the position, we would likely oppose that, saying that the court doesn't have jurisdiction. I understand Your Honor's point that historically the child may have been abused, but we would take the position that the court shouldn't have jurisdiction over that particular case if there was a non-offending parent that was capable of providing care.
Well, I think that, as I understand the law, again, as I stated it to Ms. Coburg, I'm drawing it right from the Supreme Court's case in KF, is that if there's a petition pending that has yet to be adjudicated that alleges abuse, neglect, or dependency, the court has jurisdiction, at least temporarily, over the child based on those allegations, full stop. And those allegations at this point in time at father's adjudication hearing were still pending as to mother. So no matter what the court decided at father's adjudication hearing, given that the adjudication had been bifurcated here, the court would have continued to have jurisdiction over the child because the petition was still pending, unless the state was willing to dismiss the petition.
And I agree with that recitation on KF. I do agree with that. But what's before this court is what the court found at the time of adjudication. And I want to refocus the court back to the facts of this particular case which are on appeal. And there may be in some case that argument, but in this case the court did find a pendency, and that's what they're arguing. And I want to focus the court on the Jensen v. Parker case, which says the corollary to parental rights is parental responsibilities. And I want to correct something that counsel said in terms of the shelter. It is in the record, actually, that the father had conceded at shelter, and I'm looking at the record at 64, which states that the father in this case and Ms. Kohlberg had submitted as to the shelter findings. So at that point in time, which became the law of the case, the court entered findings saying that the child in order to avoid further harm to the child, needed to be in state custody. That remained the case until you got to adjudication. And through the adjudication, in fact, that remains the case today. So you have a situation where a father, in his statement to the court at shelter, said, I agree, child needs to be in state custody. That's in the record. Never opposed at adjudication. There was never a motion filed to change that. There was never an objection at adjudication. And so as to the dependency finding, which we know is defined as proper parental care, a reasonable parent standard under the circumstances. The circumstances are, in this case, that you have a child that has exceeding, that needs a
When you say that he,
psychiatric care.
just to make sure that I've got your view of the record correct, when you say that he conceded that the child needs to be in state custody, what does that mean, state custody? What was he saying that he was agreeing that the child needed to be? Where was he saying he was agreeing that the child needed to be?
He was agreeing that the child needed to remain in state custody. And so the care.
State custody meaning what?
Meaning in the custody of the state. And I may not understand the question, that may be on me, but my understanding is he's saying that this child needs to be in the custody of the state of Utah. In other words, in the custody of DCFS in this particular case. And that effectively is what happened in this particular case. And so you have a father saying that the idea and the argument that a father may otherwise seek psychiatric care on their own, that's different than this fact scenario. And so if the argument is that he would have sought out psychiatric care.
It isn't
completely
the
on his
state
own.
who put this child in Huntsman. It was the parents.
Right, and then the child was removed from Huntsman. They had a shelter hearing, and the child was placed in the custody of
The
the
child
Division of
wasn't,
Child.
as I understand the record, the child wasn't removed from Huntsman before the shelter hearing. The child stayed in Huntsman all the way until June something.
That was the subtext of my question too, 'cause
Yeah,
that
and
was
so,
what I
and
had
so
drawn.
he has, this is Ms. Coburg's point. Father and mother together put the child in Huntsman and made the decision that the child needed psychiatric care. The shelter hearing takes place a couple of weeks later, and they're both perfect, at least father is perfectly content at that time to leave the child where they are because that's the care that father thinks the child needs. And so for that reason submits to the shelter fund. I'm not gonna contest the placement of the child right now. And I think Ms. Coburg's point is that y'all are reading quite a bit into father's position that the father took at the shelter hearing, and I think I'd like to hear your response to that.
Well, and as that may be, Your Honor, and I could be mistaken on the record, and I may well be mistaken where the child was at the shelter, but the physical placement of the child and the physical custody of the child actually changed at shelter. Even if the child was, and that was stipulated to by the father in the record, he at that point had said, and the court made those findings, that the child will now be in the custody of the state of Utah. That changed. So even if he was saying, yes, the child will be at the psychiatric care facility, I'm no longer stepping into the role of the parent to make those decisions. And he made that concession, and more importantly, never challenged that. And that remained the law of the case, clear through adjudication. So then the question is, well, is that adequate in terms of, did he meet his parental responsibilities? And I think the father, and the point that we pointed out in our pleadings, is that he did concede that issue. The child may have physically been at the Huntsman Care Facility, but given the child's needs and allegations that were made, the father conceded custody to the state of Utah. That made the child necessarily dependent on the state.
And so you're saying that when somebody chooses to, for whatever reason, again, as I explored with Ms. Coburg, this is a hearing that's taking place very much on the fly. Father gets an attorney that day. That's the first time the court was appointed an attorney for father. And, you know, at that point, you know, you participated in way more shelter hearings than most, right? So you know what they're like. I mean, they're like, you know, temporary restraining order type situations where people are sort of scrambling to do what's best for the child in the moment. And it strikes me as, I guess, odd that people would be held to their positions at the shelter hearing later. In other words, what you say at the shelter hearing would deprive you of later saying, you know what, I'm going to contest dependency here. And that's, it seems like holding people to what they say at the shelter hearings is, you know, not a very good policy for one thing.
And just to push back on that just a little bit, Your Honor, is that it's not something that happened to him in a moment of time. It's something that, a decision that the father has maintained throughout, and at adjudication was something that the court relied on. It wasn't something that happened within a certain period of hours. It may take, he had the opportunity
Well,
to
let me push
object
back
to
on that a
motion.
little bit. As I understand the record, by the time the adjudication hearing takes place, the child is no longer in Huntsman. The child is placed with a grandparent, I believe.
Correct.
And at that point, father's ready, willing, and able to resume custody of the child and asks for that at the adjudication hearing. And the state actually understands that and says, look, if there's no finding made, we're gonna have to give child back to father. That was expressly said by the state at the hearing. And so when you say that father didn't change his position and say, I want custody back, I'm not sure that's supported by the record. And help me understand where you're
And
coming from on
if
that.
and I reviewed the record on that particular point, I didn't see that at the adjudication hearing, the father had motioned or objected to placement outside of his care, that the shelter hearing, the position that he had at the shelter hearing had continued and had maintained. There's nothing on the record from my read of the record, and I don't want to misstate the record, I'm just telling you that's my read of the record, that the father never took the position that he wanted custody back. And because of that, that created a situation that the child was dependent on some other, the care of the state through no
Okay.
fault of the father.
Just to make sure I'm clear, you're not saying that what the father says at shelter has to be his position forever and always. You're saying a parent is certainly willing or able to change their position later in the case. You're just saying you don't think that happened here.
I do not think it happened here. I think that the father at pretrial could have moved the court to place in his custody, even if he had the position at shelter. And the other argument that we have, because the court was in a bind at adjudication with the child that was dependent on the state, that was in care, and the father walks in the hearing, the court is bound because there's no motion before the court to transfer custody, there's no objection to the existing custody orders. The father walks into adjudication and says, well, the child has all of these problems, but the court is bound at that point because the child is necessarily dependent on someone other than the father, particularly the state in this particular case. And even if the council had raised several concerns regarding the court's finding, and I want to remind the court that the dependency finding is a no finding. It's saying that the father didn't do anything wrong, but what is necessary and inherent in that also is that the child's dependent, which was the fact in this case.
When you say that what matters is whether the child is dependent on someone other than father, that feels like a very broad statement. Do you mean it in all of its breadth, or do you mean something a little bit narrower than that?
Well, I think I mean based on as that term is defined, dependent in the state, that the child is dependent or neglected through no fault of the parent. And in this case,
Yes,
I'm saying the child's neglected
Let
because.
me ask the question, and maybe I'm abstracting this up too high, but as I read the briefs as a whole and kind of thought about this case collectively, what I think the divide is something akin to the following. Suppose you've got a child, a teenager, who has long-term problems, drug problems, psychiatric problems, whatever they may be. And the child is in and out of inpatient facilities of some sort. And the parents are doing everything right. The parents are recognizing the problems, taking the child in and out of these facilities, but the parents are freely acknowledging, the problems are not being solved, which is why we're taking the kid to place X, Y, or Z. I think Ms. Coburg is viewing this case that way and saying, look, in that scenario, the parent can't be adjudicated, or we can't have a dependency determination because whatever problems are still persistent with the child are not due to a lack of parental care. And what I think that you and the state are saying is, no, you can have a dependency in that scenario because the child still needs ongoing care. Do I have that construct right?
I think the distinction between, and I think your recitation is correct, I think the distinction is, and all the time people provide care for their children, whether that's drug treatment, psychiatric treatment, and the state doesn't intervene. But that's distinguishable from this case where the state has intervened, the parent has conceded custody to the state, which is what happened in this case.
So is
And
this
the
case
parents-
that granular? I mean, because that's what I'm sort of drawing from the oral argument, is that you're saying that the thing that makes the child dependent is not necessarily the fact that the child is at uni, but you're saying the thing that makes the child dependent is that at some point in time in the proceedings, father said, no, the state gets custody. That's the thing that makes the child dependent. Do I have that right?
That through the case, there was a theme, and through adjudication, that the child's psychiatric needs, statements made, and threatened harm to go home, which were the findings of this case, exceeded the parent's ability to parent.
Okay,
And that was made
but
manifest.
now we're back to the construct that I was just positing. Suppose you've got a situation in which you've got two perfectly capable parents who are doing everything right, but they've got a child who has psychiatric problems and is threatening harm and is saying to authorities, I don't want to go back home. In that scenario, is the child dependent or not?
Not if the parents are willing to provide for because the child's not neglected. That's just a
But
dispute
suppose,
between a parent
but suppose you have
and
the
their
parents
child.
and the parents are saying, you know, there are times where the kid is out of control, which is why we're taking the kid to someone else, the inpatient facility. There are times where we can't handle the child because the child has problems, which is why we take the child to the inpatient facility and then the child comes back and forth. If the parents are doing their job and taking the child back and forth to these inpatient facilities, does that make the child dependent in your view or no?
I think what makes the child neglected through no fault of the parents in this scenario versus that scenario is where they're taking the child. If the parents on their own accord fund the money and provide surrogate care on their own for a child, I think that most definitely is not dependency. The child is not neglected. The child has heightened needs. The parents have taken steps to meet those needs. But this
Well, that's
case-
what happened here.
Well, but the individual, the surrogate that the parents, it was the state that intervened that took custody of the child. It wasn't the parents on their own accord.
So we're
doing
back
it.
to my
It was-
question from a
But
few
the state-
paragraphs earlier.
the state-
The thing that this turns on, if I'm getting this right, isn't that the child is in and out of psychiatric care, but you're saying the thing that turns on is that moment in time when father says the state can take custody, that's it.
Correct. I think that the child's needs are not what makes the child neglected. It is the child's needs as it relates to the parent's respective ability to meet those needs.
But the court did not make any particular findings about that, right? Dad denies abuse, but agrees that child needs ongoing psychiatric care. Full stop. There's no, and dad is not willing to take responsibility for providing that care or there's no finding about that.
And where I think that's where the law of the case comes in, that the dad had made that concession at shelter and didn't reassert his desire to have custody of the child back. Because yes, you may be correct, on the four corners, that may well be the case in terms of what, the dad didn't make that concession on the four corners, but the court was dealing with the entire law of the case.
Yeah, the state didn't get involved here because the child was having psychiatric problems and threatening self-harm.
Correct.
This Judge Tenney's example, I
Right.
mean, there are kids all over
Yeah.
the state who have that issue. The state doesn't get involved. The state
Right.
got involved here because there were allegations of abuse. That's why the state got involved, right?
Yes, that's
And
that's
those
correct.
allegations of abuse were never found to be correct. There were no findings about that, and nobody's even arguing that we should consider those as something that gives the state the right to come in. This case is not about abuse, it's about dependency, because those allegations were kind of set aside, right?
Right, and I think counsel made an argument as to what those allegations were and saying that the court shouldn't consider them, but I think it gave context to what the court, I think
But
was
the
a
court
reasonable
expressly
inference.
does not consider them as justification for the dependency determination.
Correct.
And so,
But I also
so
think
if
that
we
those.
set those allegations of abuse aside, aren't we back in Judge Tenney's example where we have a child who's having psychiatric problems? And we need to decide if the parent here is ready, willing, and able to provide the care the child needs?
No, because I think that the allegations of abuse, while Your Honor's point is true, were not the only allegations in the petition. You did have allegations in the petition that the child was out of the parent's care, and the father.
Okay,
made
let me
that
ask the question more
concession.
pointedly. What is the thing that you're saying father should have done but did not do? And where is that in the
I
findings?
think that had the father made the concession at shelter, because it was a triage scenario, that they were making decisions in the split moment, and he was assessing it, because maybe he didn't know what all the
Putting
issues
aside the
were.
concessions issue, which feels a little fuzzy to
Yeah.
me, in terms of parenting, what's the thing that you think father should have done but did not do in terms of sort of
Well,
ordinary
well,
parental care?
I mean, nothing. This is a no fault. This is
Right.
dependency, not neglect. Go ahead.
Yeah, and I guess the way I would respond to that in terms of a dependency, what I would, under the Jensen v. Parker case, in terms of, that's the way I would characterize it, is what were his responsibilities at the time? My view of that, to avoid a dependency finding and avoid jurisdiction, is the father had the responsibility at the adjudication to motion or object to the child continuing to be in state custody. The one final point, and Your Honor, if I'm.
I mean, but the
if you have
statute
more
speaks
questions.
of, it says, for dependency purposes, the child is, quote, without proper care. So doesn't that suggest that there's something that the child is supposed to be receiving that the child's not receiving?
Yeah, I believe the parent taking custody of the child. That's where the child lacks proper parental care. Where the dad didn't reassert, object, or reassert himself to obtain custody with the court, I think that's where the child lacked proper parental care. And all of the psychological needs, the allegations, the threats of harm if they go home, that gave context for the issue on why the child did not have proper parental care. But our position is where the father, failed to reassert and establish custody, that took him outside of the court's example where any other parent may have just be meeting the needs of their child. If you say, I can't meet the needs of the child, state, I'm willing to concede that you take care of this child, that's what makes the child neglected through no fault of the parent.
Okay, let me ask you one more thing before you sit down. The finding 17, child threatens self-harm if he is to return home with mom. As I understand it, there's no finding that he ever threatened self-harm. Let me just pause. I'm using the word he, the pronoun he, because that's what the trial court used. Let me just ask you now while I've
Yeah.
in mind, what are the preferred pronouns for your
So
client?
my understanding, and what I'd like to do, Your Honor, is reserve the right to submit a 24J to get the latest up to date. I did go back and look at the case, and that there was a therapist letter, and I believe it was they, them, but I'm going strictly from memory. I didn't have the ability to pull it up. I'd be happy, I understand, Your Honor, maybe
We-
writing a written opinion and you want to get it correct. So what I'd like to do is just reserve the right to submit a 24J and make sure that I've got the most up-to-date.
We would very much appreciate.
Yes, sir.
Appreciate that. So please do that with some reasonable dispatch. So anyway, back to 17. Child threatens self-harm if, I'm gonna use he because I'm quoting here. Nick, he threatens self-harm if he is to return home with mom. As I understand it, there was no finding that child ever threatened self-harm if they were to return home with dad.
That's correct. That's correct.
And then the next sentence, he told the caseworker that he just didn't want to return home to dad, but never actually threatened self-harm.
That's correct.
Okay. All right, thank you.
I guess
Anything
I'm
else
not-
you'd like to
Well,
wrap
I
up
just,
with?
the other point that we raised, sort of in a footnote, and I know I'm well over my time, and I appreciate the court's
We
attention.
we
is
took
the-
you well over your time.
Is the,
our
is
fault.
the issue, and I just wanted to draw it to the court's attention that this really does strike me as a case for invited error. And your honors have asked some really good questions, and in this case, the father conceded. He went in, he acknowledged that the child ought to be placed in state custody, he adjudicated, he allowed the court to go through the adjudication, never moved to have the child, formally, legally, never moved to change the
But
landscape.
the court's,
which form-
the court's dependency finding wasn't dependent on that, though. I used the word dependent advisedly there. The court's dependency finding he didn't say, well, I'm finding the child dependent because you've never asked to reassume custody. That was not what the court said. The court made a dependency finding on its merits. So how does invited error line up with that? Like, I could see your argument if the court had made the argument on that basis and there'd been no objection from them, but that isn't what happened. So help me understand how invited
Well,
error
and
lines up here.
And I guess if there's an argument for invited error, I think that the father should have made that point. And by not making that point and allowing the court to get to that point.
Doesn't invited error
adjudicating-
typically require an affirmative action by the party as opposed to simply not
My
making an
understanding
argument?
of that particular doctrine, Your Honor, is that that can also mean inaction, that you can be complicit in something and not act in.
Well, inaction feels to me more like a function of forfeiture, lack of preservation, whereas invited error feels more like waiver, which is some affirmative action. So if all we've got is he didn't do something, that feels more like a preservation/forfeiture problem than an invited error/waiver.
We didn't fully brief invited error in this case, and I'm happy to supplement that. I just wanted to bring it to the court's attention because when I read this, that's what it strikes me as, is you go into, you bind the court's hands, and then you argue, you allow the child to be placed in state custody, go through adjudication, and then use that, whether it was in the findings or not, that was the legal and physical reality of the case at the time of adjudication. The court's hands were bound because you have a father that at the time was not taking custody, nor legally actively seeking custody. And then to oppose that and say, well, notwithstanding, we're gonna oppose the court's finding, where it would basically divest the court of jurisdiction. With that, I'll submit unless the court has any questions.
Except that it's the state's burden to prove by clear and convincing evidence that the child is dependent.
Which I think the state did in this case.
But if you're saying that there was a lack of action on the part of the father, how does that square with the burden that is required of the state in this case?
Well, the state's burden would go to, and I may be confusing two things, because the lack of action, I think that we're talking about is as to the dependency finding or fault. But if the father doesn't affirmatively, you're right. And I think in this case, the state met their burden. They proved, and given the circumstances that the child was in custody, I understand Your Honor's point. But I think that the father too had a duty to raise that issue and affirmatively where he had made that concession and not raised it. I think he had some responsibility to change the legal dynamic, the legal landscape of the case at the time, and where he failed to do that, I think it was invited error. So I will submit that unless the court has any.
Thank you.
Thanks, Judge.
All right, Mr. Peterson, you've waited very patiently. It's your turn.
May it please the court, John Peterson on behalf of the state of Utah. I'd like to just kind of refocus, I think the real operative question here is, in all juvenile court cases is, do we need juvenile court jurisdiction? I don't know how many abused children there are in the state of Utah, but only a fraction of them is under the jurisdiction of the juvenile court. We screen cases all day long, and we don't file petitions in all these cases. There may be allegations of abuse and neglect, but the question is this a case where the juvenile court, and where you need to place, a child needs to be in DC's custody under the jurisdiction of the juvenile court? If this is merely a case, or we're talking about Judge Henry, this child needs psychiatric care. This child needs psychiatric care badly. This child is at Huntsman. Parents are taking care of the child. That child is not without proper parental care. That child does not need juvenile court jurisdiction. But this is a case where the parties all conceded, we need juvenile court jurisdiction. We need the help of DCFS and the court to manage our affairs. We are not managing our affairs on our own. We need the court and DCFS.
And you said the parties all conceded. You're referring to what father said at the shelter hearing, submitting to the removal findings.
I think that the shelter findings that you're kind of neither here nor there. At that point in
So
time.
where's the place where father concedes this? What
Yeah,
do we look to exactly?
At the point he admits to the state's petition, the court has a colloquy that says, by admitting to this court that you're submitting yourself to the jurisdiction courts and I can make orders, I can take custody of your child from you. Yes, you can. That was a colloquy between father and the court.
Yeah, that was the colloquy at the beginning of the adjudication hearing, where the court is cautioning him about admitting, because what he ended up doing at the adjudication hearing was admitting to all the facts in the state's petition, or at least not contesting them, right?
Yes.
And the court's cautioning the litigant about the potential pitfalls of doing that. Seems like we're reading a lot into that, especially where the position actually taken at the hearing is, yeah, I'm conceding these facts, but they don't add up to dependency. Seems like we're reading a lot into that to say that that was an admission that dependency existed and jurisdiction existed.
I think what he was saying though is he's saying, yeah, they don't meet dependency. It's hard to say how since dependency is no. He's saying, there's no fault here and they don't meet dependency. It's like, well, dependency is a no fault finding. Why do we have a no fault finding if it's unfair to use it against anybody who follows? It's sort of like it seems circular to me. And he's saying that you need court jurisdiction, and that's why he's asking to make a no fault or a no finding. Those don't exist. We don't have findings.
When did he say you need court jurisdiction? Because he didn't say it at the adjudication hearing in the colloquy. He just said, yes, I understand that the court can make orders if there's certain findings. So are you referring back to the shelter when he submitted to the findings?
During the adjudication where counsel is suggesting that some finding needs to be made, counsel's not saying you should dismiss it as my client has matters well in hand. He's got the child at Huntsman. We do not need your help. Dismiss this petition. They're saying we do need jurisdiction, but I don't want you to make a dependency finding. I might want you to make a different finding that doesn't exist instead to confer jurisdiction upon this court. Because at that point, mother hadn't been adjudicated. There's no jurisdiction based upon the abuse, and we're not going to file a petition against simply basis. There's many parents where one side has abused, the other hasn't. We don't file in all those cases. We file where we need jurisdiction because the blameless parent is taking care of the matters. In this case, they're not. Everybody comes in.
What other than the concession that you're referring to that you think was made either at the shelter hearing or the adjudication hearing, what finding do we have by the court that Ms. Coburg's client is unable to provide care?
No, it's not you don't have to find that the parent, you have to find that the child is without proper parental care.
Okay, what
I
finding?
mean,
What finding
trying to
do?
equate this with a bad act, but dependency inherently does not have a lack. The child is lacking. This
Okay,
child.
but their position is the child is not without proper care because father stands ready, willing, and able to provide it. So there needs to be some
Well, he
finding.
wasn't saying that at the time. He was not saying, I give you my child, I don't need you, go away, dismiss this petition. That's not what he was saying. He's saying that the child does need
I mean,
care.
it feels like you're really keyed in on the last part of the statutory standard, for good reason, through no fault of the child's parent. But the first part of the statutory standard is without proper care. So what's the finding, just to rephrase Judge Harris's question, what's the finding that we would look to that tells us that he's not receiving proper care?
That, I mean, one, he needs a secretary, but also then he's refusing, he does not want to go either parent's home. Whereas I mean, he's got to go someplace.
But that's back to the 1,000-foot level construct that I posed earlier. You could think of lots and lots and lots of scenarios in which you just have a troubled teen, and the parents are doing everything right. And if you're right, what you just said, are all of those dependency situations?
No, they're not. But again, like, why are we here? Why is everyone telling the juvenile court, we need your jurisdiction, but we just don't want to have any consequences? No one's, father does not come and say, I don't need you. I don't need anything here. That was never said. Very much, I do need you. We do need your help. We're in things.
Again, here you're referring, just to be clear, to the position taken at shelter.
No, at the adjudication as well. He's then adjudicating the state's petition, that conferring jurisdiction upon the juvenile court. He's not saying, I don't need juvenile court jurisdiction. I don't want DCFS to have custody of my child. He's saying, I do need that. Why am I here? Why are we here adjudicating a petition?
Can you point me to the record where he said that at the adjudication hearing?
Right, I mean, counsel, like, they're here, I mean, the whole college, we're here to adjudicate this petition. We're going to enter admissions to it. Why am I admitting, why are we adjudicating a petition that I don't want juvenile court jurisdiction? No one ever said we don't want juvenile court jurisdiction,
Well,
not once.
It seems like he did say that when he said, I'm admitting to the facts, but my position today is that these facts don't add up to dependency. And if there's no abuse, neglect, or dependency, then there's no jurisdiction, right?
Well, and what he's saying is they have
Ergo.
something else that doesn't exist. I mean, it's like, I don't like the choices, so I'm gonna make up my own. Third or fourth
Well,
choice.
correct me if I'm wrong, but isn't he clearly saying they don't add up to dependency? Isn't that what he's saying?
Well, kind of, I mean, but he's saying they add up to jurisdiction, but just not dependency.
Well, no,
to me.
if he's saying they don't add up to dependency,
Not dependency.
then by definition, we're not in one of those three categories, right? There's no abuse, there's no neglect, and if he's saying
I mean, but he's not,
they
I
don't
mean,
add up to dependency, then,
if he had said it, but he said they add up to something else. I mean, that's the thing is that, I mean,
but he is
It-
but he is saying that they don't add up to dependency.
it's kind of like saying, it's like, I mean, not to be too silly about it, but it's like saying there's findings that, I hit my child, but it's not abuse, it's hitting, and I want a hitting finding, not an
Well,
abuse
no,
finding.
just-
I mean, I would make
just
my
a-
own,
just
I want to create my own jurisdictional, category.
No, let me tweak that a little bit, because I think what he's saying is something that sort of fits within the parameters of your proposed hypothetical. I've been involved in criminal cases in which the state has alleged that the following conduct occurred, and the defendant, and the state says, and that meets statutory definition X, Y, or Z, which is why it's this crime. And the response from the defendant is, yeah, I'll agree that these facts right here occurred, and I may even agree that they may be some crime and they may be bad, but they're not this crime. And I think if I'm tracking all this correctly, that's what's going on here, is he's saying, yeah, I'm gonna agree to the following facts. This is the whole Rule 34E thing. I'm gonna agree to the following facts, and they just don't get you to dependency, which is what the state is charging here. Why can't he say that?
Well, I mean, it would be a different case if it simply said the allegation, the state's petition don't meet dependency, I'd like you to dismiss the state petition, but he said, no, I'm gonna admit the state petition, and I
Well,
don't think they meet dependency, but I think they meet something else.
He
which
couldn't
is
he couldn't ask that because of mother, right? The state's petition was about mother and father. So he couldn't stand there with a straight face and say, dismiss the petition.
Yes,
The
he could.
petition was gonna
Yes, he
stay, the petition was gonna stay.
No, he absolutely could. If he actually literally
That's
said,
to him.
I can take custody of my child today, I don't need your help. I don't care what mother is. In fact, you do whatever you want. We don't adjudicate petitions where we don't need jurisdiction. If he comes in and says, I'm gonna take my child, we're gonna go home, we don't need help here, this child is not without proper parental care. Then, the state wouldn't have no position. I mean, sure, okay, you take your child, you take care of things. Why are we here today?
The petition can be dismissed as to a particular parent, right?
I mean, it could be, I think it would be, if you had a parent who the child was not without proper parental care, we're done here. You take your child, you manage your affairs.
Well,
The fact that mother may have committed some abuse, there's a million parents out there who have committed abuse. They're not all under juvenile court jurisdiction.
Well, to the guardian's point, the petition isn't parent-based, the petition's child-based.
Yeah.
Yeah, and so,
I'm saying we don't adjudicate every child that's been abused in the state of Utah. They're not all under juvenile court jurisdiction. There's a lot of abuse happening out there. But this is a case where everyone said we need juvenile court jurisdiction. We just don't particularly like how the legislature set it up, so we'd like to fudge it and have court jurisdiction, but make our own finding. I guess I'm not sure if I'm out, I never had time, but if there aren't further questions, I am out.
okay, thank you, Mr. Peterson.
Thank you very much.
Ms. Coburg, back to you, and I think what I'm interested in knowing, and I think Judge Tenney probably is too, is what's your characterization of the record at the adjudication hearing with regard to the position your client took? Did your client take the position that we want state custody to remain in place, or did your client take the position that, hey, there's no dependency here and we don't think that there's jurisdiction over this child anymore?
Okay, so this is how it went down. The facts were found. I made a vigorous argument that those facts equate to a legal nothing as it relates to a finding against my client. The state responded. The court took that under advisement. For that reason, I'm not entitled to say, no, do it right now. I want my answer now. So the court's temporary jurisdiction was going to continue. He issued a written order. So if that answers your question,
Did your client take a position that day as to custody?
As-
Did you on behalf of your client
I-
say, hey, we'd like to resume custody here? The child at that point, as I understand it, is in the custody of a grandmother, right?
I think if
In the
not,
custody of DCFS.
if not in, and I want to differentiate the difference between legal custody and placement, because we're getting pretty.
Yeah, okay, fair enough. The
But-
child was
But
still.
whether he was in charge of that placement to go with grandma or aunt or whatever, I don't know if that had been accomplished, but, and now I feel kind of criticized here because how I phrased things is being attacked. But I made very clear that he was saying, you have a case against mom. Therefore, this court has fully intact jurisdiction, and he is going to cooperate with that. He wants mom to get adjudicated and get help. And he has that alternative if he wants to. He doesn't have to come in and say, Judge, I'm gonna try to somehow deprive you of jurisdiction over adjudicating the mom after the state filed the petition. Now, Mr. Peterson can say, well, we don't file these things if we have one good parent. Guess what they did? Guess what they did? And then the court still had the pending
Well,
adjudication
I
against
think
mom.
they thought they were filing it as the
Right.
father at that point because of the pending
Right.
abuse.
But- and that's
Those
kind-
were still kicking around at
That's
that
kind
point.
of my point, and Mr. Peterson makes my point. They're not entitled to an adjudication just because they file some things. And you made, I didn't kind of even understand what you were trying to impress to me, is that you meet your client and you go to shelter. And I didn't kind of get it, because I did it for 20 years. It is, you are in the trenches. That is so common that so the notion that anything that a parent decides to do at shelter should stick forever is utterly preposterous. But I await your decision on this, because if you say that it matters, I'm gonna be asking for 5-day, 7-day, 10-day shelter hearings, and I'm gonna demand appeal if that's the way it's gonna be. But I
Okay, let's
vigorously.
suppose, let me make sure I've got your position in response to what we're hearing from the other side. Let's suppose that we dig into the record here and we find that below, you/your client conceded that the child needed to be in state custody. Why doesn't that ipso facto satisfy the dependency standard, which turns on whether the child is, quote, without proper care through no fault of the child's parent? If you're saying to a juvenile court, I can't handle the kid anymore, the state needs to take over right now, why doesn't that right there, if that's true, if that's what happened, why doesn't that get you to, quote, without proper care?
Well, first off, that's not how it's phrased. It is whether the removal was appropriate in the first instance and whether removal should continue pending the proceedings. So it has never been intended on it being a concession for all time. It isn't, I'm saying, please take the child. It's
So you're
like,
saying the
I only have
concession
so many
doesn't
brain
get as
cells,
far as-
and I'm gonna need them to beat my head
Let
against
me
the wall
parse-
for adjudication.
let me parse that out a little bit. I think Judge Tenney's right, that if a parent stood up and said, look, I can't care for this child for whatever reason, there needs to be state involvement. That's sort of the core definition of dependency, right? Dependency, the term dependency, as I understand it, derives from the notion that the child is dependent upon the state for care. And if the parent concedes that the child is in fact dependent upon the state for care, then that could be a basis for a dependency finding. But that isn't what the juvenile court decided here. In other words, the juvenile court didn't say, oh, because you conceded continuing jurisdiction of the court, ipso facto, we have dependency. No, the court went in and made these other findings about self-harm and not willing to return home and needing psychiatric care, and on that basis, the court found there was dependency. So the court certainly didn't understand your client to be making a dispositive concession that day, and the court didn't make its determination on that basis. But if that's true, though, that would be a ground for dependency, wouldn't it?
Yes, and that's why I wanted to point out when Judge Forster was asking me about that, does the child need psychiatric care? That finding ends at my client agreed the child needed psychiatric care. But there was no and that the dad is not willing to take care of it. I vigorously argued, you guys, all these facts amount to a legal nothing. That's what you have. And then the court took it under advisement. And I implore you to search that record. Never, never, never did my client say, I need the state's help. Never. He was cooperative, he was proactive, he was going along with it. He never asked for anything. And I went from shelter to demanding speedy trial within 60 days, which people look at me and say, you're insane to ask for adjudication in 60 days on allegations like this. I demanded it. I think there's a written demand in there because I was not going to let this stand. And that I needed to go hat in hand and say, well, but could I have something more than adjudication? I went in, as far as I'm concerned, I prevailed on adjudication. I think the findings established that I prevailed on adjudication. We didn't go to trial. They caved and gave me the facts. The facts do not support dependency, and the court took it under advisement. I couldn't ask for, hey, while you're mulling this over, Judge Johnson, and I give him credit. He did a great job in trying to parse this out. But I wasn't going to get anywhere saying, while you're thinking about it, as to whether you agree with me about the no finding and whether you agree with them about dependency, I'm demanding custody back. I had to await his findings and his order, see what he decided. For all I knew, I was going to win. I usually don't, but it could happen. So I'm waiting his findings. Then I immediately appeal, and here we are.
If the ruling had come down the other way, would you have asked for custody? For placement, I guess?
If he said, yeah. And here's the thing. This isn't legal custody. You are absolutely spot on. And that is not, do we leave together today? And yes, I'm going to go get the kid from wherever, but it's my legal decision as parent where this child goes. Whether the child is with me in the sense of physical custody, but legal control. And that's what we're talking about. I'm in control if the child goes to grandma. I'm in control if the child stays with me. I'm in control if I find another psychiatric facility that's inpatient that I think. It is legal custody, not
Because the parental presumption has been restored.
Exactly. And that's what I was arguing for. It's not up to you, state of Utah, to decide whether that child goes to grandma or aunt or dad. It is that parent's right, if they can't prove dependency, to say, you know what, we didn't prove our case. You've done what you needed to do. It was reasonable. It was in the scope of ordinary parenting, to use the court's kind of paraphrase, and you earned it. You had it to start with. We didn't take it away from you. You're entitled. Thank you so much. This
Okay.
was This was so much more exciting than I thought it would be. So I'm sorry your lunch is late.
You know, our arguments aren't often referred to with that adjective, but we'll take it.
We'll take it.
We'll take this matter
And I
under-
apologize again about my phone ringing.
Anyway, thank you for coming down, and
Your Honor, I'll follow the 24J on the pronouns.
I would appreciate that, and welcome to you. I haven't seen you here before. I'm glad to have you here. We're glad to have you all here. But we'll take this matter under advisement and get you a decision as soon as we possibly can.
Thank you, Your Honor.
Thank you.